To anyone familiar with my blogs or website, it comes as no surprise that I really enjoy the law of 93A and 176D for my clients in dealing with insurance companies. That law, or those two statutory provisions, allow a client to assert that an insurer has a fiduciary duty, even a third-party insurer, and I'll explain what that means, to conduct their claims handling, their claims investigation and negotiation in a fair and reasonable manner. When I say third party, I mean if A is suing B and there's no relationship between the two other than that B caused A's accident, that's a third party situation and it leads to a third party lawsuit. And the fact that 93A is applicable in that context is extremely helpful. We're not talking about what's called first-party insurance, turning to your own insurance company and saying they have not dealt fairly with me in adjusting the fire damages and adjusting the value of a vehicle or anything of that nature. Here we're dealing with tort cases, which are third-party cases, and we're dealing with the insurer on the third party. So 93A has, as I said, it's been a weapon that has allowed fair play in litigation, and it has leveled the playing field. Recently, I was investigating the law of another state, another major industrial state, Pennsylvania, and it was with some surprise that their statute, which talks about unfair acts or practices in business or commerce, is not applicable. It is not available in these tort cases, in these third-party lawsuits. The actual law says that Pennsylvania courts will not permit a person who has been hurt to have a direct action against the insurance company for the at-fault person or party, and that they have no duty, those insurers, to act in good faith to the entities that are suing them. This is a very different proposition from what we have in Massachusetts. And I, as a lawyer of personal injury victims, want to make sure that insurers, their feet are held to the fire and that they act in good faith, and that they investigate the claims in good faith and they negotiate the claims in good faith. And even though I'm dealing not with first-party insurance, but I'm dealing with third-party insurance, I can rely on the law in Massachusetts that those insurers have a fiduciary obligation to my third-party clients, and that my claims or my clients will have to have their claims handled in a fair and reasonable manner. Thank you.